through the imaging, the lab testing. Then the medical team was able to rule out some of those possibilities. And then some of those studies also provided support to other possibilities. So once everything was completed and injuries that I outlined previously were found, I believe that abusive head trauma is most likely diagnosis.
And we had talked earlier about like limitations in coming up with something. Were you able to read any police reports?
No, I don't think I read police reports.
Did you have access to any statements from the parents as like the investigation went on about admissions or statements about what happened?
I believe, yes, that I had just conversations with police about some possible histories or mechanisms of injury.
Okay.
Important, if at all, is the history you receive from, let's say, a caregiver or parent when a child comes to the hospital.
So I believe it's important so that medical professionals can kind of tailor the treatment, or again, kind of move those potential diagnoses around in that list of what's more likely. So if we're given a history of an injury or a potential injury, then we might be able to kind of look for additional injuries, or again, kind of potentially get to imaging and diagnosis sooner.
So would it be fair to say that it's important that history is as accurate as it possibly can be?
Yeah.
Thank you. You were asked about kind of different scenarios where the baby's head might hit a person's arm, where the head might not be supported. Would any of that describe or be consistent with the injuries that you saw in Daryl Jr.?
No.
Including the fracture to the tibia?
That's correct, yes.
And you were asked why you call it a most likely diagnosis, and of course you said it's because you weren't there, you didn't see what happened. Is that common in your field of work, is that there aren't people who are what we would call witnesses to what happened?
That's correct.
Thank you. Nothing further, Your Honor.
Can I ask one follow-up, Your Honor?
You may.
Doctor, you said you had access to the University of Michigan records. Did you also have access to the records created by Tia Braxton?
I believe so. She is part of the maternal infant health program.
Well, she is the at-home social worker that does the home visits. And were you able to review those as well?
Yes.
Did you review the notes for the day that Daryl Jr. was admitted to the hospital?
Yes.
And are you able to share what those notes say?
I'm going to object, Your Honor. At this point, that's hearsay unless there's some reason there's not.
Respond.
Well, I'm just trying to figure out how what's in those notes plays a role in her diagnosis.
I get that, but I'm going to sustain the objection.
Okay. I guess we'll have to ask her.
Thank you. Anything else, Ms. Tapp?
No, thank you, Your Honor.
Thank you, Doctor. You may step down. This witness can be excused. No objection. This witness is excused. You may call your next witness.
You will call Dr. Carl Schmidt.
Take a seat, raise your right hand. Do you solemnly swear and affirm the testimony you're about to give be the truth, the whole truth, and nothing but the truth? State and spell your first and last name for the record, please.
My name is Carl, C-A-R-L, Schmidt, S-C-H-M-I-D-T.
You may inquire.
Thank you, Your Honor. Hi, Dr. Schmidt. Thank you. Good afternoon. Thank you for your patience. Dr. Schmidt, could you please tell the court where you were employed in August of 2024 and in what capacity?
At the University of Michigan Department of Pathology, professor of pathology, also Deputy Washington Continental Exam.
Thank you. Could you please tell the court about your educational background and training?
I'm a physician, licensed practice president in Ohio, Michigan, and Washington State. I have residency or specialty training in anatomic and clinical pathology. Then I have subspecialty training in forensic pathology, and I am board certified by the American Board of Pathology in anatomic, clinical, and forensic pathology.
Thank you. Your Honor, if I may approach, and I'll show defense counsel what's been marked as People's Proposed Exhibit number 3. He was also sent that before the hearing today.
Is it 3? Yes, you may. Go ahead.
Dr. Schmidt, I'm handing you what's been marked as People's Proposed Exhibit 3. If you could please tell the court you recognize what that is. Your Honor, I would move to admit the CV, People's Proposed Exhibit 3.
Any objection or voir dire?
No objection.
CV is admitted, Exhibit 3.
Thank you. Dr. Schmidt, have you testified in court before?
I have
Approximately how many times?
at least 400 to 500 times.
Have you been qualified in court as an expert before?
I have.
In what field?
Mainly anatomic, clinical, and forensic pathology.
Thank you. Your Honor, at this point, I would move to qualify Dr. Schmidt as an expert under MRE 702.
Any objection, voir dire? Pardon?
No objection.
All right.
That's a lot of court appearances.
All right. And this witness is so qualified.
Thank you. Thank you, Your Honor. Dr. Schmidt, could you tell us a little bit about what forensic pathology is?
Forensic pathology is the branch of pathology that studies how and why people die, the changes that occur in tissue as a result of the process of death, not only with trauma, but also with natural disease. And we also look at laboratory testing.
Thank you. And as part of the position you had in August of 2024, and I'm sorry, August and September, I should say, of 2024, did you perform and supervise autopsies?
Yes.
Could you just briefly tell us the procedure for autopsies?
So the autopsy is basically consists of 2 parts. The first is where you do a basic general exam of the body that includes things like height and weight, as well as looking for evidence of disease as well as injury. And after you're done with that, then you proceed to what is probably more popularly thought of what happens during an autopsy, where you open the cavity of the head, chest, abdomen, pelvis, look at the internal organs, and you make a correlation with what you see in the internal organs with any external phenomena, if that is well.
And did you supervise the autopsy of Daryl Hicks Jr.?
I did.
And as a part of the autopsy process, would you complete a report documenting findings and conclusions?
Yeah.
Was a report completed in this case?
Yeah.
Was it completed at or near the time of the autopsy examination?
It was sometime after the autopsy exam because there were several procedures that we had to do that were started at the time of the autopsy, but could not be completed until later.
Okay. And I'm going to ask you a little bit more about the procedures in a moment. Before I do, Your Honor, may I approach, again, I'm showing defense counsel what's been marked as People's Proposed Exhibit number 4, but he should have that as part of the discovery.
All right. Yes, you may approach.
Thank you. Dr. Schmidt, I'm handing you what's been marked as People's Proposed Exhibit number 4. Could you please tell the court if you recognize what that is?
This is a copy of the autopsy results generated in the case of Daryl Hicks.
And how do you know it's associated with the case of Daryl Hicks?
Oh, because it has his name on it and it has an autopsy number generated as part of the Washington County Medical Examiner. Record keeping, it also has an autopsy number, which is the way that it's kept track. The Department of Pathology State of Hicks.
Thank you, Your Honor. At this point, I would move to admit People's Proposed Exhibit number 4 into evidence.
Any objection or voir dire?
No objection on that, Your Honor.
All right. Exhibit 4 is admitted.
Thank you. May I approach with exhibits 3 and 4, Your Honor, to publish? Schmidt, I'm going to ask you some questions about that report, but before I do, at the conclusion of the examination of Daryl Hicks Jr., was there a determination as to the cause of death? And what was that determination?
Abusive head trauma.
And was there a determination as to the manner of death in the case of Daryl Hicks Jr.?
Homicide.
Could you please tell the court what injuries you noted on Daryl Hicks Jr. specifically that led to those determinations?
Well, the first is that he had something called diffuse subarachnoid hemorrhage. So the brain is covered by a very fine membrane, which has a very rich blood supply. And when that membrane becomes implicated, hemorrhage, that's what we say that is subarachnoid. So basically, the entire surface of the brain was painted with this subarachnoid. Then there were scattered subdural hemorrhages. Basically, there was a subdural hemorrhage is a hemorrhage that is a clot that occupies the space between the skull and the surface of the brain. So a subarachnoid hemorrhage will sit on top of a subdural hemorrhage will be sitting on top of a subarachnoid hemorrhage. So it's a sandwich, if you will. You have the skull, then the subdural space, then the subarachnoid, and then the brain itself. Another way to think about a subdural hemorrhage is that when you open the skull, you peel away a subdural hemorrhage, whereas a subarachnoid hemorrhage is painted on the surface of the brain. A subarachnoid hemorrhage is an indicator of trauma. And in this case, it was basically all over the surface of the brain, called diffusely spread across both hemispheres, especially more weighted towards the left side of the brain. But the subdural hemorrhage extended down to another structure of the brain called the cerebellum, which is kind of like a smaller version of the brain that's seated next to the brainstem. So I guess the long and the short of it is that there was extensive subarachnoid hemorrhage, basically covering the entire surface of the brain, except for a small patch. Then there was what we call diffuse hypoxic ischemia. What that means is that the brain was deprived of oxygen because of decreased circulation. When this child suffered the trauma that resulted in all this hemorrhage, there was inflammation of the brain. And as the brain swells, there is an increase of pressure within the skull. The skull is basically a hard enclosure. And as the brain tries to swell, well, there's not much room for the brain to swell because the skull is itself helping to contain the pressure that builds up. And at some point, pressure builds up to the point where it exceeds the ability of blood pressure to pump blood through to the brain. So that you get what we call the hypoxic injury, which is basically that loss of blood flow that happens to the brain as the increase in pressure within the skull impedes the ability of blood to flow into the brain. I hope that's.
Thank you.
And then there were patches of hemorrhage within the cortex. You will see that the autopsy report, there's something called diabetic confusion. What that means, it's a bruise that happened because of tearing or sliding of the cortex over the white matter inside the brain. It's basically two layers of brain with different densities sliding over each other as the trauma was inflicted. And when that happens, there are blood vessels that are keeping those two layers of the brain together and they get torn. So you get the hemorrhage, which we call shearing contusion. Then there was the hemorrhage in the optic, in the retinas and the optic nerve. So to do that, we look at the eyes directly, and there was hemorrhage within the retina, which is the pigment, that black pigment layer in the back of the eye. That was also infiltrated. The hemorrhage, there was hemorrhage in the optic nerve, the right optic nerve that comes out of the eye. And there was also hemorrhage in the neck. At the spinal, there are 7 cervical vertebrae, and in levels 5 and 7, there was hemorrhage in the nerve roots that come out of the vertebrae, out of the nerves at that, out of the spine at that time.
Thank you. Did you note anything in particular regarding the essentially the skeleton, if you will, like bones? Was there anything noted?
No, and well, not in the head, but there was a fracture of the right tibia, injury to the growth plate.
Could you tell us a little bit about that, please?
So it was in the bottom of the tibia, what we call the distal tibia. It was going to the ankle, to the knee. And basically there was trauma inflicted to that part of the leg, which resulted in breaking the growth plate. And you can see that there was hemorrhage in the growth plate, and we actually removed that part of the leg and took sections from it to look under the microscope, and you could see that there was hemorrhage there.
So going back to the injuries you observed in the head, what does that indicate to you? What does that suggest to you may have happened to cause those injuries?
You can think of injury as a transfer of energy to tissue. There is no injury that happens without hemorrhage being transferred to tissue. So this is a pretty extensive injury. The diffuse subarachnoid and subdural hemorrhage, intense swelling of the brain that caused the pressure of the brain to rise to a point where it basically heated blood flow into the brain. All this is a catastrophic event, which which leads me to think that something really bad happened in this child very acutely. I can't tell you exactly what it was. For several reasons. One, this child had actually survived for 8 days, 6, 7, or 8 days after he was admitted to the hospital. But this child was either shaken, that's one possibility, or his head was impacted against a padded surface. A padded surface would help spread out injury, and thus you would not see any injury on the skin as a result of being struck on a padded surface.
When you're conducting these examinations or supervising them, do you also consider the history of, did this child have a normal birth? Have there been any previous issues prior to the onset of symptoms that led to this? Okay. In this case, was there anything that had occurred, to the best of your knowledge, that would lead to these injuries from the medical records prior to this child coming to the hospital in August and September?
There was not.
And how does that play into your diagnosis?
Well, it just lends weight to the diagnosis of trauma as being the reason behind all these changes.
You mentioned you used the word acute. Could you describe to us what you mean by that?
It means that a lot of this happened with a very short period of time. This child was apparently well until the moment that he wasn't, and then he developed seizures, became abducted, and was taken to the hospital. This happened within a very narrow period of time, which is supportive of the fact that this was a major injury suffering.
I do want to ask you about going back to the tibia, the right tibia. And you noted acute fracture of the distal metaphysis at the, I'm not going to try to pronounce all of that, but I'm referring to page 8 out of 10 of your report.
Okay.
What type of movement might cause that kind of injury to the tibia?
You know what? Hold on one moment. Young man. Yeah. Yep. Miss Tanner,
I'm sorry, Your Honor?
might want to move to the side. Bring him up here. What's your name?
Ashton, you know,
Pardon?
Ashton.
I gave a warning. You were in here when I gave the warning. No, don't even try it. I saw how you walked out. I saw how you looked at him. I saw how you flipped your head. I didn't want to see that. I asked that everybody be respectful to everybody else. All right, so if you come back in this courtroom ever, you make sure you behave yourself accordingly. Understood?
Yes, sir.
You can go.
I'm going to ask you a question again, referencing page 8 out of 10 of your report regarding the right tibia. What type of movement might cause that type of an injury?
This can only be caused by one of two things. One of them is the leg was impacted against the surface such that it caused the growth plate to get displaced. This is not a fracture like an adult where the bone hits something and because of the impact at that point, the bone splits. This is a cartilage. It's growth plate. So instead of bone kinking, it kind of gets displaced, like shearing one end of the tibia over the other. And the other possibility is that it was squeezed. That's how we think these things are fractured.
Would something like a light squeeze cause a fracture like that?
No, to cause a fracture like that, paralysis, I think requires significant amount of pressure.
Thank you. Nothing further.
All right. Cross-examination.
Doctor, so I want to ask you about the potential of a blunt force impact. I think your testimony was that, this could be shaking, this could be a blunt force impact that couldn't be excluded. Could you describe what is a blunt force impact?
Blunt force impact is when body part strikes an object such that it can leave behind a bruise or not, but there is no actual breaking. So for example, if I strike you with my fist, that would be an example.
Okay. And that cannot be excluded in this case.
Correct.
You spoke about, in the blunt force impact, that would be an acute occurrence, right?
Right.
You talked about how injuries are the result of like an energy transfer. I'm sorry if I didn't use the right words that you said.
That's correct.
How much force are we talking about that would be required to produce such an injury?
I can't tell you in numbers what actual force is needed. There is literature from the motor vehicle industry that have looked at how much energy can be generated in a motor vehicle accident. You can find dummies, for example. But in this case, suffice it to say that this is a significant injury that required a significant amount of force just because of the extent of the injury.
And I think you had talked about how the injury is so diffuse. Could that be related to the blunt force impact on a soft surface, making it so diffuse?
Yes.
Okay. You had said that it would be a significant amount of force to result in the injury in regards to a blunt force impact, but you're not able to describe, like in numbers, what that would look like. Are there any studies or anything out there that you could point to help me read on this that would describe that, or do we not have that?
As I said, the motor vehicle accident literature does have references mainly regarding crash testing and the like.
Okay.
But this is not something that you can actually do because you can't.
Right. So it's fair to say and if I'm hearing you right, there's not studies on this because it's impossible to actually study it.
Correct.
There's estimates, but we don't know for sure. Let me ask you the same thing about potential shaking. I mean, do we know what type of force would be required in a shake to cause an injury?
No. No, there are papers that talk about not just the energy, but how fast the head needs to vibrate and so on. But it's obviously an experiment that you really can't do. What we know about shaking is because there have been published articles by pediatricians such as Suzanne Starling that look at cases of subdural hemorrhage with swelling of the brain that were taken from individuals that confessed actually doing this. And their value lies in that many of these stories were actually, many of these descriptions of shaking were actually obtained before there was a diagnosis of shaking baby syndrome.
So if I could sum up then, it's fair to say that we can't say that such a shake would cause such an injury, right?
That's right.
And there's no way to really get a firm answer on that.
Right.
But you can say with medical confidence that it could be, either a shake or either a blunt force impact.
Right.
Doctor, I want to ask you about the fracture again to the right tibia. Was that fracture a fracture that had healed as if some time had passed, or was that a recent fracture?
Recent.
And as far as you were aware, and at the time you performed this, or as you're sitting here now, Daryl Jr. was never in a car accident.
Right.
Thank you. Nothing further.
All right.
No other questions on that, Your Honor.
Thank you, doctor. All right. How many more witnesses do you have?
Your Honor, I actually have no further witnesses, and I was going to ask, I've had Deputy Singer waiting, and I'm not intending on calling him, so if he may be excused, I'll make sure he gets home.
All right.
Well, I'm going to call Detective Yeager then if Ms. Tanha's not going to.
All right. So why don't I do this? While we prepare for that, you can then release your witness. I'm going to take a brief recess. Back on the record in the case of the people of the state of Michigan versus Darrell Hicks.
Good
And
afternoon, Your Honor. Marie Tanhas, Assistant Prosecuting Attorney on behalf of the people.
Same person with none.
all right. And the people have no more witnesses and have rested. Mr. Bernstein.
I'm going to be calling Detective Brian Yeager to the stand, Your Honor.
All right. Very good. Sir, please come forward and be sworn.
Testimony about the food, the whole truth, and the whole truth, nothing else. Statements about the first matter,
My name is Brian Yeager, Brianyeager.
All right. You may inquire.
Good afternoon, Detective. I know it may be somewhat odd for defense counsel to call the OIC when you are otherwise not called, but here we are. So this was a case that you were the investigator on, right?
Yes.
And you had several occasions to speak with Mr. Hicks.
Yes.
And on one of those occasions, that was at the Washtenaw County Sheriff's Department.
Yes.
He had come in, this is a prelim, so he had come in to do a polygraph test, right?
Yes.
And there was like a pre-interview session with Detective Babbage before that.
Yes.
And you were like observing that session.
Yes.
And you heard the conversation that was made during the conversation.
Yes.
And you ultimately wrote down that conversation in your police report, right? So, Mr. Hicks says some things that could be considered admissions against his own interest, right?
I'm gonna object as to counsel characterizing what the statement may have been interpreted as. I think there's a more direct question. Yes.
Any response to that?
I mean, that's fine. I can rephrase it, Your Honor, if that.
Thank you.
I thought I was skipping a
Take the
step.
objection, rephrase.
What did Mr. Hicks say regarding,
I'm gonna object, Your Honor, hearsay.
Yes. Response?
let's try again, Judge.
Sure, why?
Did Mr. Hicks make any admissions that day?
Yes.
What did he say?
Objection, Your Honor.
Sustained.
Judge, why can't I ask what,
Because it's hearsay.
other statements against his own interests?
It's classic hearsay. That's one of the reasons why it's hearsay, because you can't get the testimony of the defendant in by that means. He would have to waive his right, because what protects him is his right to not testify. So you can't get his testimony in by taking it through some other means. It's hearsay. That's why the rule's there in Great Park.
But
So the objection is sustained. You can argue with me all night long if you want, but I'm telling you, it's still going to be sustained.
I just only wanted to argue for 2 more minutes, Judge. But generally speaking, when police officers get up there, they talk about what the defendant said.
Because they're not the ones.
Because the prosecutor's calling them.
Your Honor,
Yes.
if I may clarify, victim is not considered a party.
Yes.
Counsel is, as I would presume, on the side of the defendant as he's representing him, not a party opponent.
Correct. That's one analysis. See, the other was the one I gave.
Well, I guess I can't get what I want to get in, and Ms. Tanner made a good move by not calling Detective Yeager, so I think we're all done.
Appreciate the compliment, Your Honor. Nothing further.
From this witness. All right. Thank you. You may step down. Thank you. I think that's the shortest time you've ever been on the stand before. All right. Any additional witnesses for the defense?
There you are.
Do I have
At
a
this point, we would move for bind over on all of the counts in
response?
I do have a response, Your Honor, and I of course, didn't get as much in as I was hoping to, which somewhat undercuts me, but it is what it is. Look, I mean, the first-degree child abuse cases, People v. Maynor is the law, and that is, it's not just that a person might have an intent to commit an act. The person must intend to commit the injury that followed that act. And that's from People v. Maynor 470, Mich. 289. And, Dr. Schmidt just testified, he said to cause an injury would be significant force, but we don't exactly know what amount of force a shake leads to an injury. We don't exactly know how much force a blunt force impact would have to cause an injury. The distinction here when we're talking about first-degree child abuse is that the person needs to intend for the injury that follows from an act. And that's what's not on the table for Your Honor to consider. There's no admissions for Mr. Hicks. There's no witnesses to an act. And we don't have anything that shows that, even at a probable cause stage, there's just nothing on the table that shows he had an intent to create some sort of injury from an act.
Going to be an issue for the jury.
Well, I think it's also
making the argument that I'm to try to figure out his intent. I couldn't make that determination anyway at this stage. That's for the fact finder. That's clearly a question.
Of course, the jury instructions say knowingly or intentionally caused the injury. And so there has to be, in the Maynor case, says more than intent to commit an act, the person must intend to commit the injury that followed the act. And that's what's not present here. And that's what I'm arguing is needed for a bind over, Your Honor, that there needs to be that intent to commit the injury. That's what knowingly and intentionally committing an act leading to serious physical harm means. And that part is in the jury instructions in the statute, Your Honor. And so that's what's not present here. And my argument is that without that, there's no first-degree child abuse that has been shown. There's not been shown proofs that there was intent to commit that act. They're not knowingly or intentionally would be the language.
But
Yes.
Mr. Frampton, if by something occurring to this child, which it did, and not immediately contacting his primary caregiver, that being his mother, that could be an indicia of some intent on his part, but not something I can decide here. I mean, that's what I'm getting at. I mean, you can now you argue, but that's clearly a question of fact. And
I hear what you're saying, Your Honor. I think there was some evidence that there was a meeting with a medical person at the home where this was discussed. And Dr. Parkin Joseph said that medical neglect played a role in some of the injuries that were here. And I mean, you know, a medical person saw the baby. You know, he was not instructed to do something otherwise. So I think there is something there, Your Honor, that shows that, you know, he brought this up to someone and laid it out there and was not told otherwise. So it's not, you know, did he call mom? I mean, he told an at-home social worker.
okay, but it's still not something I can resolve.
Well, I understand the constraints that Your Honor is faced with the factual presentation here. I don't think there's enough elements there for first-degree child abuse, and the charges that flow from it, I don't think can go either, Your Honor. So that's the basis of my argument.
Any response? I don't necessarily need it, but go ahead.
Not that I have argument. I do want to make a clarification because we are going to have a transcript. So I want to be very clear.
Yes.
There was no testimony from Dr. Parkin Joseph that this was medical neglect. I want to be very clear about that.
But I think there was like a contribution of medical neglect. I mean, she said it was in her consultation notes, Your Honor.
Your Honor, it was considered, and we are all very happy that you considered all possibilities and then jumped straight to abusive head trauma. So yes, it was considered. That is not the cause of C's injury. She could not have been more clear. Thank you.
I would ask the court to please consider my arguments. I think I'm on point. I think it's in this. I think Maynard supports my argument, Your Honor. Thank you.
Well, then I'll start with count two, since that is the predicate offense really for count one. The court believes that there is sufficient evidence to, first of all, he's the only one in the care of this child, the only one that, at least by the testimony that the court has before it, has access to this child. It is clear from the medical testimony that during that period in time, between the time that the defendant has care of that child and then mom returns to get that child, something acute, something traumatic happened to this child. On that, quite frankly, the court believes that it may be up to a jury to decide what the defendant may have known at the time, what he may have done knowingly or didn't do knowingly. But those are all questions to be decided by a jury. I can't make that determination here. Further, to the extent it needs more analysis, the issue of one's intent can be shown by what they did, how they did it, what they didn't do, what they said, what they didn't say. Any other facts and circumstances can be used to show someone's intent. A jury could come back and determine by his lack of saying anything, his lack of contact, and I'm not saying that they should or shouldn't, but a jury could come back and make that determination that he intentionally did this because something had happened to that child. Again, that's up for the fact finder. But for the purposes of probable cause, given that that could be what a reasonable fact finder could conclude based upon what I have before me, I think the people have indeed sustained their burden of showing the necessary to show the offense of child abuse in the first degree. And so therefore, the people having shown that to sufficiency for this court, I would bind the defendant over on count two, since it is a predicate offense and there was indeed a death involved. Then the court would also bind the defendant over to stand trial on count one. And the court also does believe that there is sufficient evidence shown by the testimony in this case that the defendant properly would be bound over and should stand trial as to count two, murder in the second degree. Therefore, the people having sustained their burden, the defendant is bound over to stand trial on all three counts.
May I approach to sign the information?
In my calendar, Your Honor, I have a copy of the information. Waive any further reading. Stand mute.
Defendant having waived formal reading, standing mute to all three counts. Court will enter a not guilty plea. Pretrial will be set for
June 30th at 1:30 p.m. with Judge.
June 30th, 2025, 1:30 before Judge Cohn.
June
Do I
30th, Your
believe it's
Honor?
a Judge Conlon case?
I do have Conlon here. Where you- Well, I have the file marked that.
I was just going through the splits, but if your file says Conlon, I can give you a copy.
Thank you.
Looked like Hunky on my little spreadsheet thing.
It looks like it on your, oh, no, I have this as Conlon.
Okay, Judge Conlon is July 2nd at 1:30.
July 2nd, 2025, 1:30. Before Judge Conlon.
Thank you, Your Honor.
Ron will continue as said. Thank you. Do you think she did your job? Meet her. What did you prosecutor? Yeah, okay, here's what we're gonna do. I want this side over here to hang on. Let's get these individuals out of the courthouse. And then we will release you guys, okay? Get yourself out of my court.
So cool.
Everybody can remain seated. I'm gonna step off and then we'll figure out what Mr. Warren Green is going to do in my life. All right, court statement. Court calls the case of the people of the state of Michigan versus Sean Johnson.
Alexander, on behalf of the people, Your Honor.
Good afternoon, Your Honor. Alex Warren Green on behalf of Mr. Johnson. Your Honor, today's the date and time for preliminary examination. I appreciate the court's accommodation in passing this matter earlier. I did have an opportunity to speak with my client. My client does wish to proceed with examination, knowing that the people do intend to proceed using the exception laid out in MCL 768.27C. And I think he understands that by proceeding, the people would be rescinding their offer of not adding any habitual offender sentencing in exchange for his waiver.
Okay. And sir, that is your decision?
Stand up.
That's your decision?
Yeah, my attorney said that,
Well, I don't want to know what's your discussion.
no, witness. Or,
Mr. Johnson, when we spoke, I explained to you that there is an exception to the general rule laid out in MCL 768.27C, under which a prosecutor could make a showing and the prosecutor could have a preliminary examination without the presence of the person who directly accused you of this. You understand that, right?
yeah,
Okay, so you understand that if we proceed right now, we are going to have a preliminary examination, right?
but you said in the back if she
Well-
wasn't here that I would be let go.
Okay, hold on. Because I really don't want your conversations on the record. Why don't I take a break, let you discuss with him in more detail as terms of what he wants to do. So why don't I give you about another 15, 20 minutes and you guys can figure it out. Because I want to make sure he understands what he's doing, particularly since there may be habitual offender charges that could be filed.
Thank you, Your Honor. I really appreciate
Because I don't want anybody to see my expression. Yes. It's okay. Does call the case of the people versus Sean Johnson.
Alexander, on behalf of the people, Your Honor.
And Alex Warren Green on behalf of Mr. Johnson. Mr. Johnson, can you state your name?
Sean Johnson.
All right. And are we going to have a preliminary examination? Going?
The people are ready to proceed.
And Your Honor, I did have an opportunity to speak with Mr. Johnson at length. I think Mr. Johnson understands people's position. At this time, he does wish to waive his right to a preliminary examination. The people in exchange have agreed not to add any habitual offender sentencing enhancements. Could you sign?
All right. Mr. Johnson, is that correct?
Yes.
I'm sorry, are you, I think you said yes, but your handcuffs hit, but,
Yes.
all right. And Mr. Johnson, you understand, I'll let you finish signing there. You understand that a preliminary examination is a proceeding where the people would have to show by the standard of probable cause that the offense alleged was committed and that you committed it. You understand that, sir? Yes?
Yes.
All right. You understand you'll not have that hearing and you'll proceed to circuit court for further resolution of this case. You understand that?
Yes.
All right. People also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendant is bound over to circuit court on the single count. Mr. Warren Green.
Your Honor, we acknowledge receipt of the information, waive its reading, and stand mute.
Defendant having waived formal reading, stand mute. Court will enter a not guilty plea. Pre-trial in this matter will be set for
June 26th at 1:30 PM with Judge Slade.
June 26, 2025, 1:30 before Judge Slade.
In Your Honor.
Is there anything sooner than that? Please.
Hold on. Because that's, you may be right, because that sounds like an exam hell date.
I'm just giving you some willy-nilly. How do you like May 22nd?
We'll get you a quicker day, May 22nd.
Okay.
Thank you, Your Honor.
May 22nd, 2025, 1:30 before Judge.
I just want to talk to my daughter, Your Honor.
In Your Honor.
Hold on a second.
Yes.
I did want to bring to the court's attention, after the defendant's phone privileges were revoked last time, he did try to attempt to make a call with the same number to the victim, but the victim's number was blocked from the jail. I am concerned that he tried to call that number again.
I don't want to punish my daughter.
Hold on,
Your Honor.
Mr. Johnson.
Johnson, let me just say this. I revoked your phone privileges because I felt that I had to. You would have been entitled to a hearing and the like. But sometimes, sir, what you got to do is you got to let the process work itself through. And if you keep trying to force things and do things, it's just going to cause you more headache and more problems. I'm not going to take any action on what the people are raising, okay? But I'm going to suggest as this case proceeds toward Judge Slade that you not enter into that behavior.
I just want to talk to my daughter.
I know, but you'll get there. You'll get in a position to do that sooner if you follow the rules that we have now, okay? Bound with its conditions will continue. Thank you.
Thank you, Your Honor.
What is the bond anyway?
It's $15,000 cash. And we can pass that in Judge Slade's court on the 22nd, right? Sure.
Thank you.
Thank you, Your Honor.
I'm sorry I couldn't.
No, you didn't, sir. What we're here for.